A mother wishing to place her child for adoption must relinquish her parental rights. Once she's taken that step, can it be undone? That's the question in Vela versus Marywood. Karina Vela was 19, pregnant, and unmarried. Vela went to Marywood, a licensed adoption agency, for counseling. She met repeatedly with Moore, a Marywood counselor. Vela told Moore she wanted to place her child for adoption. Vela also told Moore she wanted post-adoption visits with her child. Throughout their counseling sessions, Vela and Moore discussed a sharing plan that would allow Vela to select the adoptive family, visit her child regularly, and exchange letters and photos. Such sharing plans were typical at Marywood. Adoptive parents would be told about the plan and would agree in writing with Marywood to abide by it. Marywood and Moore knew these agreements weren't legally enforceable. Vela met with the adoptive parents, who expressed openness to post-adoption visits. Shortly before the birth, Moore and Vela reviewed the affidavit Vela would sign to relinquish her parental rights voluntarily. Moore told Vela that once she signed the affidavit, she couldn't undo it. Vela had a baby boy. 4 days later, Moore brought the affidavit to Vela at the hospital for her signature. Vela was hesitant. Moore promised that Vela would always be in her child's life. When Vela asked how Marywood would guarantee that, Moore assured Vela that Marywood would encourage the adoptive parents to respect Vela's wishes and reminded her that they had agreed to the sharing plan. Based on these assurances, Vela signed the affidavit. Moore never told Vela that after signing the affidavit, she wouldn't have any legal right to see her child or that the sharing plan was unenforceable. Within days, Vela contacted Marywood to undo her relinquishment of rights, without success. Marywood petitioned to terminate Vela's parental rights based on the affidavit. The family court terminated Vela's rights before she could intervene. The district court affirmed. Vela appealed to the Texas Court of Appeals.